Hello, everyone. I'm JR Dukes with JRDukes.com. I appreciate you joining me today. Today, we're going to talk about an article that's in Forbes magazine. It was a few months ago, back in December of 2020, and the author is a Jay Atkinson. Atkinson, I guess I can say his name. At any rate, I think this is a perfect illustration of the perils of dealing with when you're dealing with bankruptcy and bankruptcy trustees. A lot of people think, hey, if I have a issue with credit, if I have an issue with a bill, if I'm unfortunate enough to fall on hard times or something along these lines, hey, I'll just go ahead and file for bankruptcy. What people don't understand is that bankruptcy itself is not always what I would call a clean-cut deal. There are many pitfalls that has to do with bankruptcy and bankruptcy trustees. Basically, what people don't understand, and you have to be very, very careful of, is that the so-called bankruptcy trustee, and by the way, bankruptcy trustee, doesn't that sound like someone that's nice, someone that's going to help you, someone that's going to fairly administer justice and make sure things are taken care of? Well, what happens in reality is the so-called bankruptcy trustee actually turns around and hires his own law firm to go around and start drilling on your body. And what I mean by that is they are empowered by the federal bankruptcy courts to go through your records, go through your finances, and start drilling. They are what's called a super creditor. They can contact anybody that you may have wrote a check to, anybody you have any financial obligations to, and they have basically superpowers. They can set aside transfers of property. They can set aside and reclaim money that you may have given someone, even money that you may have given someone for services rendered. You have to be very careful and understand the risk when it comes to filing for bankruptcy. So I think this case is right on spot. So let's get right into it. I didn't read this article in Forbes. It's titled Debtors Transfers from a Non-Debtor Limited Partnership Set Aside in Cold. So Cold is the name of the case. And we're going to read through this quickly. In 2002, a Florida real estate developer, William W. Cole Jr., and his wife, Terry Cole, created a limited partnership domiciled, meaning located in Nevada, and called it Cole of Orlando Limited Partnership. The owners of Cole of Orlando were William and Terry as 49.5% limited partners, each interest being held by the Coles in their own individual revocable living trust. The remaining 1% was owned by a general partnership interest, which was held by a company called W&T Cole LLC, also a Nevada company, which were owned by William and Terry as tenants by the entireties, what is referred to as T by E, tenants by the entireties. The limited partnership invested in stocks and bonds, which is remarkable since very few real estate developers own anything other than, you guessed it, real estate. This is basically a normal type of setup. People routinely, when they set up limited partnerships, they generally will do it with their spouse. And as in this example, one may own 49.5%, the other one will owe 49.5%. They will either own it in their own names or in a trust, and that's what they did. They had a revocable living trust, generally for estate type of purposes is what they're trying to do that for. And then the managing partner of the limited partnership generally has a 1% interest in the limited partnership, and they are also vested with the duties of actually running the limited partnership. At any rate, 6 years later, in 2008, the real estate market crashed. We probably all remember that. Anyway, later that year, William personally guaranteed $10.5 million or so in existing debt and another $11.5 million or so in new debt. But William didn't survive the crash. And on December 15, 2011, the lender, which is called PRN, which stands for PRN Real Estate and Investments Limited. So that's the name of the company, referred to as PRN, called the guarantee, on which by that time was more than 12 million in outstanding debt. 2 weeks after Williams the personal guarantee was called, Cole of Orlando transferred more than 2 million to an account owned by William and Terry as T by E, which is tenants by the entireties. A little side note is that TBE, tenants by the entirety property, is generally not available to creditors. In order for a creditor to get a hold of TBE property, they generally have to have a judgment against both parties that are holding the party, TBE. So just keep that in mind. At any rate, within 2 weeks, Cole of Orlando transfer almost another 2 million to TBE account, giving the Coles close to 4 million in TBE property and leaving little, if not anything, in the limited partnership. Basically, they were taking their money and, I guess you could say, getting ready to do what they want with it, kind of run with it, get rid of the companies and move on, which you'll see what happens here in a minute. Any rate, about 5 months after these transfers, in June 2012, the Coles entered into a settlement agreement with their creditor, PRN, by which PRN agreed to forbear collecting the debts against the Coles so long as William paid a percentage of his earnings to PRN to satisfy the totality of his indebtedness to PRN. By that time, it had risen in excess of $30 million. This deal lasted for about 2 years before William defaulted on it as well, and PRN sued William in state court. So they paid on the arranged settlement, so to speak, for 2 years, and then he stopped paying on it, and then PRN had to turn around and sue in state court. Now, keep that in mind. Cole jumped, by doing this, right? Cole jumped from the frying pan of the PRN state court case into the fryer of bankruptcy in July 2015, when he commenced a Chapter 7 bankruptcy case. I would say it like this. I wouldn't say he jumped from the frying pan into the fryer. I would say he outright jumped from the frying pan into the flames. This is where you mess up, and you have to be very, very careful. At any rate, eventually, the bankruptcy trust appointed, they have it spelled wrong here. Eventually, the bankruptcy trust should be trustee appointed to hear the case, filed a fraudulent transfer action against the Coles relating to almost 4 million that Cole by Orlando Limited Partnership paid to William and Terry. First, the transfers were intended to defeat PRN's collection rights. Second, the transfers were made at a time the Coles were insolvent, and the transfer lacked what is called REV, which stands for reasonable equivalent value. And third, the transfers violated Florida law, which prevents the fraudulent conversion of non-exempt assets into exempt assets. William made a number of arguments in his defense. The first was that the limited partnership, Cole of Orlando, was not the debtor and therefore was incapable of making a fraudulent transfer. The problem here is that the bankruptcy court has no power to unwind transactions where the debtor may have had legal title to the assets, but does have control over those assets. To this, William argued that he didn't control the partnership, but instead it was controlled by W&T Cole LLC. But of course, he controlled that entity as well. So here's what the court determined, and I'm quoting, applying the control test here, there is no question the transferred funds belong to Cole. Recall, Cole of Orlando was formed primarily to invest in stocks, bonds, securities, and other intangible assets on behalf of Cole and his wife. Cole held the family's wealth in Cole of Orlando. When Cole decided to wind down Cole of Orlando, the partnership's assets were not distributed to Cole and his wife's revocable trust. They were transferred directly to accounts owned by Cole and his wife as tenants by the entireties, which is the T by E. Cole made all of these decisions. He was in control of both Cole of Orlando and W&T Cole. Stepping back and looking at all circumstances, I conclude Cole had control over the transferred funds, and it is deemed the legal transferor, end quote. All right, that's basically strike one. Cole next argued that he decided to empty out and close down Cole of Orlando when Florida repealed its intangible tax, such that there were not longer any benefits to maintaining the limited partnership. The court didn't doubt that Cole's reasons for shutting down the limited partnership, but noted that such did not explain why Cole of Orlando transferred its cash to William and Terry, not individually, but as T by E property, which was exempt from PRN collection efforts. Thus, based on this and other undisputable facts, the court ruled that William had caused Cole of Orlando to transfer the nearly $4 million to his and Terry's TBE account for the purpose of hindering, delaying, or defrauding PRN, which is the creditor. See, and that's where they always get you in these bankruptcy trustee type cases is, are you trying to hinder, delay, basically defraud the creditor's attempt to collect? Anyway, it goes on. The court moved on to the issue of whether the transfers from Cole of Orlando to the T by E accounts was for REV, reasonably equivalent value, and noted that the purpose of the REV requirement was to make sure that the debtor gets back roughly equal value in transactions such that the debtor's estate is not depleted. On this point, William argued that since PRN, as the creditor, would have been limited to only a charging order against his and Terry's interest in Cole of Orlando, which is of dubious value to the creditor, in the end, PRN was actually better off because the money ended up there in the TBE accounts. Kind of a creative way to make that argument, but it ain't going to hold up. It goes on, there were numerous problems with this argument, noted the court, such that PRN would have had a lien on the Cole's interest in the limited partnership, such that when it was finally wound up, then PRN would have received Cole of Orlando's assets via PRN's charging order. But most importantly, the value to PRN of the Cole's TBE accounts was precisely zero, since these accounts were exempt from collection. Moreover, by causing Cole of Orlando to transfers that nearly $4 million out of its own accounts to the Cole's TBE accounts, the value of the Cole's interest in the limited partnership went to zero. Thus, PRN could not collect against the Cole's interest in Cole of Orlando, since those interests were now worth zero, and PRN could not collect against the Cole's TBE accounts because they were exempt. Thus, and I'm going to start quoting again, this is from the court, so creditors lost access to the value of Cole's shares in the assets in Cole of Orlando. They got nothing in exchange, and Cole put up a barrier to future creditor claims by parking the money in an exempt TBE account. He received no reasonable equivalent value in exchange for the transfer. This is a classic example of a constructive fraudulent transfer subject to avoidance because the creditor's estate was depleted because of these transfers. When you end up in bankruptcy court, and by the way, I'm ending quote, when you end up in bankruptcy court, the bankruptcy trustee is going to have anything and everything set aside or basically undone by the federal bankruptcy judge, where essentially you gave away money, you gave away assets, you gave away your estate, and you did not get something of value, of equal value back in return. And that's what happened in this particular case. All right, the article goes on. William also argued that there were no fraudulent conversion, which is different than a fraudulent transfer under Florida statute, which prevents a debtor from converting a non-exempt asset into an exempt asset, such as TBE, for the reason that the Cole's interests in the Coal of Orlando were effectively exempt. Williams' theory here was that PRN's remedy against the Coles Limited Partnership were restricted to a charging order, which is a pretty lousy remedy for a creditor. But when Coles of Orlando's property was transferred to the TBE accounts, it became available to PRN because an exemption to TBE protection is when a creditor hold a judgment against both spouses, as I was talking about earlier, assuming that PRN would ultimately be able to ascertain a claim against Terry, his wife, as well as William. The court did not buy this argument either and noted that Cole has it backwards, which he does. It goes on, even if a charging order is a pretty lousy remedy for creditors, it is still a remedy. At the very least, it would have given PRN the right to distributions from the limited partnership. A charging order may do nothing. So a charging order may do or not do a lot of things, but it is not an exemption. Next, as to TBE property, whatever might or not happen to a claim against Terry in the future, the bottom line was that the particular point in time when the transfers were made, there was not joint claim against Terry, and the assets became exempt as TBE property. Thus, the monies went from being held in a non-exempt limited partnership interest to being held in exempt TBE accounts, and that is a fraudulent conversion. Based on these rulings, the bankruptcy trust, I think he should have put bankruptcy trustee. That's what he's trying to say here. The bankruptcy trustee won a partial summary judgment against Cole on the fraudulent transfer of the fraudulent conversion claims. That's a fancy way to say he just had all of this set aside and had it all undone, all these transfers. It goes on, but there was one more issue of interest before the court. Apparently, in 2010, William transferred 3,000 shares of Google stock to Terry, and Terry moved for a partial summary judgment on the grounds that the transfer was time barred. In other words, it's been too long. The bankruptcy trustee can't do anything about it. However, the bankruptcy trustee was pursuing her claims under the Florida Uniform Fraudulent Transfer Act, which provides for a 4-year extinguishment period, often incorrectly referred to, including by the court here, as a limitations period, but which is very similar, but also a 1-year period from the date that the challenge transfer has been or could reasonably be discovered by the creditor. Terry claimed that PRN should have known in 2011, when Coal of Orlando was being wound down, that the transfer of Google stock would be made, or have known of the Google stock transfer from their financial reporting made at the time of the 2012 settlement agreement. But the court found that there were material facts in dispute as to what PRN knew about the Google stock and when, and so denied Terry's motion for partial summary judgment, meaning that the issue will be tried along with the other remaining issues. In other words, it would be a question. There were questions of fact is what the court ruled. So there would have to basically be a jury trial, or, at least some kind of trial before what we call the trier of fact. So here's the analyst of this particular case, and then I'll get some commentary. All right, the author goes on. This opinion illustrates the perils of a debtor's control of funds, and even if the debtor technically does not own them. It goes on that the so-called control test, as explained, and he cites a particular case here, a bankruptcy court has the power to avoid either a preferential transfer or a fraudulent transfer. Preferential means where you decide to give it to one creditor over another creditor. Generally, the reason you would want to do that is one of the creditors might be able to help you out in some particular manner. At any rate, it says the bankruptcy court has the power to avoid either a preferential transfer or a fraudulent transfer of the third-party funds if they are controlled by the debtor, at least to the extent that the transfer has the potential to diminish the value of the debtor's bankruptcy estate. That is what happened here. By transferring the funds out of Cole of Orlando, William diminished the value of his limited partnership to zero, and thus the court could avoid the transfer. But what is the value of such avoidance? William would presumably argue that even if the transfer from Cole of Orlando is avoided, the funds should go right back to Cole of Orlando, and PRN would then be stuck with a charging order lien against William's interests, and would then have to wait until distribution so that the interests were made, if ever, to receive anything. The problem, and see, here's the key of this whole article here. This is what I really want to drill down on. The problem with this argument is that William already closed Cole of Orlando to be wound up. And so when the court avoids the transfer, the monies come out of TBE accounts and land in Williams' individual and non-exempt name as a liquidating distribution, such that they become part of his bankruptcy estate, and the bankruptcy trustee will take possession of these monies. But even if William had not wound up, even if William had not wound up Cole of Orlando, the bankruptcy trustee could have obtained a money judgment against William's TBE accounts for the amount of the transfer under Florida statute such and such. So either way, the bankruptcy trustee would have ended up with the cash. The irony here is that the $4 million in Cole of Orlando would have been very likely protected from PRN had William simply left it there. This is what I'm talking about right here. You think you need to do something. You think you're very smart. In this type of situation with this type of money, he didn't consult a lawyer. Apparently, he definitely did not know what he was doing. Someone gave him bad advice. I don't know, but he definitely made a terrible mistake here, and it's obviously going to cost him plenty. It's sad, but it is what it is. PRN would have been stuck with a charging order against Williams' interests, but nothing required PRN to make any distribution. So what happens with these charging orders, and the reason why I love LLCs and the reason why these charging orders are so fantastic, is that once a creditor has a judgment against an LLC, most states specify that the sole remedy is what we call a charging order against the LLC, or that person's interest in the LLC. In other words, if they were to receive a distribution, the LLC could be forced to pay the distribution to the creditor. However, the LLC generally just does not ever make a distribution. It will get money to the judgment debtor another way, which is perfectly legal. It is just a fantastic benefit to having an LLC, and generally, because it's very complicated and there are other tax implications for the creditor holding a charging order, generally they don't want to mess with that. But anyway, going on, it says very likely the Coles, okay, I'm going backwards a little bit, could have left it there. PRN would have been stuck with a charging order against Williams' interest, but nothing required PRN to make any distribution. Very likely the Coles could have then settled with PRN on some basis where PRN got relatively little, but that's still better than nothing. And the Coles would have then been able to keep the rest of the money peacefully. One might observe that this is yet another case of a panicked debtor, meaning a debtor in deep financial distress who compounds his problems by making bad decisions that make things worse. That is exactly what I'm talking about. This guy probably panicked. He thought he had to do something. Sometimes as human beings, it's just our nature. We feel better if we take action. We feel better if we do something. And oftentimes the best thing to do is do nothing. If they would have simply left the money alone, they very likely would have been able to walk away with a big chunk of their money. But because he transferred the money out, to these TBE accounts. Then he wound up or closed the limited partnership. When it went before a bankruptcy trustee or a bankruptcy judge, the bankruptcy trustee was able to have that transferred to the TBE accounts set aside, and basically the court will reverse the transaction. The problem is, because Cole shut down his companies, there was nothing to be undone. In other words, you can't put the money back in a dead corporation or a dead LLC. Therefore, the money would have to go back to the Coles individually and personally, therefore allowing the bankruptcy trustee to reach the actual cash, meaning they lost everything. Just very sad. It says William probably made three major errors. William caused the money which were safe in Cole of Orlando to be transferred to TBE accounts, which then created the potential for avoidance as what ultimately happened, what I just got done talking about. Number two, William wound up Cole of Orlando such that the transfers could not be reversed, voluntary or involuntarily, back into the limited partnership where the funds were substantially protected. And three, William commenced a case in bankruptcy court, which, as we see in so many of these cases, is the most singular factor in an asset protection vehicle failing because of the very strong statutory and equitable powers of the bankruptcy court to unwind transfers and look through entities. So, that's pretty well the end of the article. It's basically what I was just telling you. Three major mistakes. He had to do something in his mind. He transferred the money out. Bad mistake transferring it out of there. I mean, it's just, I don't know, it gives me chills to really think about it. That's a lot of money, because as business people, we all can have something bad happen. We could have bad times happen. But when you act and you don't think things through, this is what can happen. And I can tell you unequivocally, with very few exceptions, you better think very, very hard before you file for bankruptcy protection, because that's probably the single most important factor that basically has caused this husband and wife team to lose it all. And I don't want that to happen to you. So just always be thinking through those type things. If you have any questions or comments, or if you think I missed anything, please be sure to let me know below. I do read all the comments, and I'm happy to respond or answer any question that you may have. My friends, I definitely appreciate you joining me today to go through this particular case. I think it was definitely worth the time. If you enjoyed today's video, I would appreciate it if you would show your gratitude and hit the thumbs up button. Please subscribe to my channel, and be sure to tell your family and friends about my channel, as I'm trying to build my channel day by day. I do appreciate your support, and I want you always to remember to have a free mind and never give up. Until next time, friends, I am JR Dukes.